Ready? Exercise number 59, legal matter, start. Though at the stage of granting bail, an elaborate examination of evidence and detailed reasons touching the merit of the case, which may prejudice, should be avoided. But there is a need to indicate in such order reasons for prima facie concluding why bail was being granted, particularly where the accused is charged of having committed a serious offense. Stop, next para. We are constrained to observe that in the instant case, while dealing with the application of the accused for grant of bail, the High Court completely lost sight of the basic principles enumerated above. The accused in the present case is alleged to have committed a heinous crime of killing an old helpless lady by strangulation. He was seen coming out of the victim's house by a neighbor around the time of the alleged occurrence, giving rise to a reasonable belief that he had committed the murder. We feel that under the given circumstances, it was not the stage at which bail under Section 439 of the Code should have been granted to the accused, more so when even charges have not yet been framed. Stop, next para. Is also pertinent to note that, as stated above, the additional Chief Judicial Magistrate had rejected 3 bail applications of the accused, but the High Court did not find it worthwhile to even make a reference to these orders. In this regard, it would be useful to refer to the following observations echoed in Kalyan Chandra Sarkar versus Rajesh Ranjan. Stop, next para. In regard to cases where earlier bail applications have been rejected, there is a further onus on the court to consider the subsequent application for grant of bail by noticing the grounds on which earlier bail applications have been rejected. And after such consideration, if the court is of the opinion that bail has to be granted, then the said court will have to give specific reasons why, in spite of such earlier rejection, the subsequent application for bail should be granted. Stop, next para. The jurisdiction to grant bail has to be exercised on the basis of well-settled principles having regard to the circumstances of each case and not in any arbitrary manner. While granting the bail, the court has to keep in mind the nature of accusations, the nature of evidence in support thereof, the severity of the punishment which conviction will entail, the character, behavior, means and standing of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witnesses being tampered with the larger interests of the public or state, and similar other considerations. Stop, next para. It has also to be kept in mind that for the purposes of granting the bail, the legislature has used the words reasonable grounds for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy it as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. Stop. Thank you very much.